Is the United States against Sullivan. Counsel for the appellant, you may proceed.
May it please the Court. My name is Major Jeff Liebenguth, and I represent the appellant, Sergeant Jeffrey Sullivan. With the Court's permission, I'd like to start 2 minutes of my time for rebuttal.
Granted.
For the first issue, the military judge erred in excluding evidence of EM's mental health treatment for 2 reasons. It was relevant, and it passed the MRE 403 balancing test. In terms of relevance, the defense theory of the case had 3 straightforward points. First, that EM armed herself with a K-bar knife in the Camp Pendleton home and was attempting to hurt herself. Second, that appellant disarmed her. And third, EM lied about what happened, alleging that the appellant assaulted her because she wanted to get attention from
What evidence did the judge have before him that she had hurt herself in making this ruling? What evidence that was admissible in court was the judge aware of at the time he was asked to make this ruling?
None, Your Honor. But
so he was to allow exploration into her mental health based on no evidence before the court.
Well, Your Honor, this would skip ahead to the end of my argument, but critically, after the appellant offered Dr. McMichael's testimony, which would have laid out all of the evidence supporting their theory of the case, that was precluded. The defense then asked them, we'd like to put EM on the stand. But they also thought that they could get this evidence to support their theory of the case from. That was denied. At that point, the military judge ruled that that type of evidence was not going to be allowed from any witness. So even at that point, if the appellant had taken the stand and testified as to what his version of what went on in the Camp Pendleton home was.
When you say that type of evidence, can you be specific about what the defense counsel wished to put on? Because on appeal, it's mental health.
Yes, Your Honor.
But in the record of trial, it was specific. It appears to be more specifically related to cutting and suicide ideation. But what is your characterization?
Your Honor, the defense counsel, on the fly, was using very generic terms to describe all of the evidence that was going to be offered by Dr. McMichael, which included her past medication use, the cutting that she endured, the family dynamic in terms of her craving attention from her mother, how she competed with her other siblings and cousins for that. So when he said that her self-mutilation or self-ideation was talking about general mental health, he was talking about everything that Dr. McMichael had testified to, which the judge ultimately precluded.
Did the judge preclude any questions to the mother or to EM about wanting the mother's attention?
No, Your Honor.
Did the defense counsel ask the mother or EM about coveting the mother's attention?
No, Your Honor. Importantly, as the defense counsel pointed out, there was already evidence, though, in the record showing that EM was being untruthful. That is, she gave numerous different stories as to how many times the appellant had assaulted her. In addition, the defense put on 2 witnesses, Mrs. Plazola and Mrs. Jackson, both of whom effectively testified that EM had lied about what appellant did in that Camp Pendleton home. But despite this, and despite this court's support for bias-type evidence being liberally admitted, the military judge nonetheless precluded it. And in so doing, he relied on the wrong case. He relied on United States v. Imberio. And the critical point the judge missed with Imberio is that in that case, the evidence offered by the defense was not going against the accused. If you recall, in Imberio, the defense wanted to offer evidence of Mrs. Imberio's mental health. They didn't want to call in a psychiatrist showing that someone who, like Mr. Imberio, angered, might shake a baby. The defense theory was then going to be that maybe it was Mrs. Imberio and not Mr. Imberio that shook their young son. But Mrs. Imberio wasn't the accuser, and that's what we had in this case. And in Imberio, this court simply said that there was no nexus, that that evidence wasn't relevant. Here, the evidence was offered against the accuser.
But I guess my question is, how exactly did the defense at trial tie in her psychological problems to a motive to fabricate?
Your Honor,
I mean, I understand that you would like to have that information to perhaps make her seem like a crazy person. But how does the fact that she had psychological problems have anything to do with the motive to fabricate? And if not, what was the proper basis of relevance for that information?
Simply the fact that she had psychological problems did not create the motive to fabricate on her. But this was like, they needed that to create the foundation. That is, she had these psychological problems, and as a result, there was this hospitalization issue. That is, her mother...
How does that give her a motive to fabricate? The fact that she's going to be that she has psychological problems that might require hospitalization. How does that make her into someone who's lying about what happened that day?
Well,
especially since, in response to Judge Baker's questions, the defense didn't ask any questions about any of the things that they could have asked questions about.
Well, Your Honor, if after one of her cutting incidents, which was back in 2005, the last one being in 2007, her mother was open to having her committed if this conduct continued, and then she attempted to cut herself again in the Camp Pendleton home, just like in Moss, there was a motive to change her present circumstances. That is, if my mother finds out that I was trying to self-mutilate again, she may have me committed to a mental health treatment. Now, we may not agree with that. We may not think that that would have won the day. But it wasn't the military judge's place to make the decision. There was nothing fanciful about this. This was a garden variety criminal case. You had an alleged victim coming in and saying the accused did something. They wanted to probe her truthfulness on that issue. As this court has said, whether the witness is biased or not is always relevant. While some of the pieces were not laid out as well as we would have liked by the defense counsel at that particular time, when he offered Dr. McMichael's testimony, from opening statements, the defense laid out what its theory was, and even in the middle of the case, he argued to the military judge that our theory of the case is this young lady armed herself with a K-bar knife and tried to hurt herself. That's found in Joint Appendix in 83 through 85. The fact that the military judge couldn't make that connection.
There doesn't need to be any evidence presented to make the connection with, so the defense counsel can come up with any theory they want and then go find any medical record to support it. That's what I don't understand. It's a great theory, but don't they have to have something that supports it?
They did, Your Honor, and it was this evidence they would have brought out in a cross-examination of PM or the examination of Dr. McMichael. And his Supreme Court
did he testify that she would self-mutilate to get attention?
No, Your Honor.
No, he did. Okay. Didn't he testify that she was in a kind of halcyon period prior to this incident?
Yes, Your Honor.
Yes, he did.
That was to the defense's benefit, though, Your Honor, because, as he mentioned, her self-mutilation was cyclical. She'd self-mutilate, and then she'd have long periods of no self-mutilation. The last time she'd self-mutilated was in January 2007. In September 2007, on the 22nd, was her birthday, and the doctor testified that...
Did he testify that her birthday was a triggering event, or did he testify that other dates were triggering events?
Well, he didn't testify that the 22nd was a triggering event, Your Honor, nor could he. The last time he had seen her was on September 10th.
Mm-hmm.
But the defense could have gotten up in closing argument and argued to the members that a logical inference is that the 22nd she became very stressed and exploded like a volcano.
Well, and I'm back to where Judge Baker is. Where's the foundation for all this? They could have gotten up and argued it, but where's the foundation for it all?
Your Honor, if the military judge wanted more of a foundation, if he wanted the accused to take the stand or allow this evidence to be admitted only on condition of the accused testifying as to what went on in the Camp Pendleton home, he could have done so.
He repeatedly asked, I must say that the judge is begging for them to make the relevance argument.
Yes, Your Honor. And
page after page he says, please make the connection, please make the connection. And you're faulting the judge now for not asking them to make the connection, but it was about 5 or 6 times in a row he says, I'm open for business, make the connection.
I think the connection was made, Your Honor. The standard for relevance is very low. You had evidence before the members in which could be argued she was lying. That is, Ms. Jackson and Ms. Plazzola's testimony, as well as the evidence of the numerous different stories EM had given on how many times the appellant had assaulted her. This was enough to allow the members to hear the defense theory of the case. And the court was well aware of the appellant's CID statement. That statement is in the record no less than 5 times. If the military judge wanted the appellant to testify, then he could have asked. But he never did that. And instead of allowing the defense to get up and use that evidence to aid the trier of fact, what they were left with is a distorted record. They were left with one picture, and it was entirely presented by the government.
If the military judge had said, I'm only going to let this in if the accused testifies, what would our situation be in that point?
It would be problematic, Your Honor.
Might be. And so let's focus on the evidence that the members had before them, that the judge had before him at this point. What specifically was the fact at issue that's relevant to this case?
Whether or not EM was telling the truth, Your Honor.
And what specifically was the evidence that the defense wished to offer on that, including any foundation or proffer, that the military judge excluded?
That was excluded, Your Honor, was that she wanted to get attention from her mother.
And that evidence would have been offered by the expert?
The expert's testimony, Your Honor, would have, yes, it would have provided this competitive atmosphere for the members to understand in terms of the family dynamic between.
Okay, one, that she wanted attention from her mother. What else was excluded by the judge that was relevant to the issue of whether she was lying?
The hospitalization issue, that the EM's mother was open to having her daughter committed if the self-mutilation continued.
And what about the cutting itself? What was the evidence of that?
Well, Dr. McMichael testified as to her cutting, as well as the cyclical nature of it and the triggering events that could bring this.
And what would he have testified as to triggering events?
The triggering events could be any holidays, really, where EM was missing her lost loved ones.
And what evidence was there of any triggering event at or near the time of the incident that formed the basis for the charge?
Yes, Your Honor. The 22nd of September, the day before the alleged incident, was EM's birthday.
Thank you.
Did the doctor say any birthday, or did he say in particular Thanksgiving, Christmas, and the sister's birthday?
He said those were more of a concern, Your Honor. But on further questioning by the defense counsel, he clearly established that her birthday could be a triggering event.
What was the elapsed time between the thinking about hospitalization and this event?
It was a number of years, Your Honor.
It was a number of years, was it not?
It was.
Isn't that pretty stale?
No, Your Honor, because Dr. McMichael actually indicated that whenever he saw EM and discussed the psychological treatment of her daughter with her, they always talked about them needing to be open to this. It was in there a couple of times.
He discussed it with whom?
With EM's mother.
With the mother. And are you just supposing this got back to EM?
No, Your Honor.
Well, then, I mean, you're saying that the judge erred in keeping out this supposed fear by EM of hospitalization.
Yes, Your Honor.
And then you're saying, well, he talked about it with her mother during this 3-year elapsed period. But is there anything on the record to say that got back to EM?
It's a logical inference, Your Honor, considering you would think that she's involved in her own treatment. I think just as the members could logically infer that because the appellant was a close family member, that he could know something about her psychological treatment and her medication use. In regards to the 403 balancing test, the military judge basically found that even if the evidence was relevant, that there was too much of a danger that the members would improperly use this evidence. First, the military judge could have given an instruction on how this evidence was to be used. He could have ensured that the defense only argued their articulated reason for bringing it in, which was to show motive to fabricate. Additionally, the judge's reason is kind of flawed here. When you have a 17-year-old girl who had undergone numerous tragedies within her family and was receiving psychological treatment for that, there's really nothing about that that would cause members to think that she might fabricate a story. So the danger the military judge saw there was really, it didn't exist. Why would someone who had these tragedies in their family make up a story against their cousin as having assaulted them?
Oh, isn't that the exact opposite of what you want to be arguing? I mean, if the very things that you want to put in aren't going to show that, give any evidence that she fabricated, why would you want it in? I mean, isn't that exactly why the military judge didn't want it in?
No, Your Honor. The reason the military judge was just because she had psychological issues, she would therefore be more likely to lie about something, taking out all of the other issues. Just because someone has psychological troubles doesn't mean they might lie or they would lie in a particular case.
Isn't that the defense theory?
No, Your Honor. The defense theory here is her motive to fabricate. Certainly the psychological issues brought about the other motive, that is, or the motives that were articulated by the defense. That she wanted to get attention from her mother.
Yeah.
She feared hospitalization.
That's the motive, but they didn't ask the mother or the victim about that.
And you said the fact that was an issue was whether she was telling the truth, and that you wanted those two, that evidence in to go to that point, which was the evidence of the hospitalization, the mutilation, and the psychological evidence that she wanted to get attention from her mother.
Yes, Your Honor. The distinction we're trying to make here is with the government's citation of United States versus Butts, where in Butts they said, just because she has psychological issues doesn't mean she has an irrational hatred or view of the people she's accusing of committing a crime. That's not what we have here. In Butts, the evidence was kept out because of that. So that's the distinction we're trying to make. Certainly the psychological problems came first, but the motive to fabricate is a result of it. And it starts with that first layer of her. Without psychological troubles, we wouldn't have the motive to fabricate because we wouldn't have her fearing hospitalization by her mother, and we may not have that craving, the attention she's craving. This is a girl who, since the age of 12, had been undergoing psychiatric trouble, which that's one of the points, is that the government was allowed to portray her as just a normal teenager. When, not to disparage her, but someone who's been undergoing psychological treatment at that young of an age, up to the age of 17, is not your garden variety teenager.
Counsel, do you have a question, Judge?
I was just going to say, how does any of that have anything to do or relevant in any way as to whether or not she was fabricating this particular story on that particular day? I mean, that's the connection that I'm at least missing, and I think that the military judge was missing it too.
Same amount of time.
No, you can go ahead and answer that question.
Just like in Moss, Your Honor, the critical question there, the court found was that she may have wanted to change her present circumstances. And that's the case here. She may have wanted to change her present circumstances, i.e. get more attention from her mother, and at the same time, she may have wanted to avoid being hospitalized, which her mother was open to.
Well, and if you could just, on rebuttal, be prepared to explain how, with respect to the wanting more attention to her mother, you were precluded from asking either her or her mother questions on that, yet failed to do so. And with respect to the second issue, how this, whether there's any evidence whatsoever that the mother was planning on hospitalizing her, that she had any knowledge of that fact.
Yes,
because otherwise, it all seems pretty speculative.
Counsel, you can address those questions now or on rebuttal as you prefer.
Rebuttal would be fine.
On rebuttal.
Okay. Thank you. Counsel for the government.
Chief Judge Efron, may it please the Court. I'm Captain Eckert on behalf of the United States. The military judge's 15th finding of fact, no triggering event occurred in this case, is supported in the record, and therefore appellant's proffered evidence lacks any nexus to the charged acts. It was properly excluded under 401. The evidence fails under 401 for a number of reasons. First, it's too remote to the charged acts. It lacks in temporal proximity. Second, it doesn't actually prove what appellant claims it does. And finally, it lacks a sufficient nexus. The military judge also bases ruling on 403, which is another sufficient basis to exclude the evidence. And finally, though not a basis for the military judge's ruling, the government believes this evidence could also have been excluded under Military Rule of Evidence 513. Appellant's theory.
How is it?
Let's do it again.
Okay, go ahead.
What rule should the judge, well, let me try that. Defense argued this under what theory? 404, 608, etc. And then what did the judge rule on? And did the judge make his ruling on a correct view of the law?
First question, Your Honor, only 608. They disavowed a 404 argument. They said it was not character evidence. The military judge based his ruling on strictly relevance under 401 was the first prong of his ruling. He said, though, if this evidence were to have any marginal relevance, it would then be also excludable under 403.
So in your view, the military judge's ruling was not based on either 608 or 404, but rather was a straight 401, 403 shot?
Well, I think the military judge articulated that if it actually went to bias, then it would, of course, be relevant. But his finding was that the theory of bias presented was never sufficient to go to the members, so it lacked any relevance.
You mentioned 513.
Yes, sir, only on the basis that the first prong, of course, of 513 is the evidence relevant. So the EM wouldn't have been...
You're not saying anybody claimed a privilege in this?
No.
Okay.
No,
well, you know, because there's no privilege unless somebody asserts it.
Right, Your Honor. But if the military judge were to rule the evidence as to be irrelevant, there would be no need to cite the privilege.
So it's the government's view that when the expert testifies that trigger events could include holidays, other birthdays, other events of that nature, that it was a decision for the military judge to make, not for the members to make, as to whether a birthday occurring a day before the incident in question would be a triggering event.
Well, I think it's a matter for the military judge to make, Your Honor, when you have this theory of bias that stretches over years and it takes these three lines.
I'm just talking about the triggering event issue. Why is not the birthday a triggering event if all those other events are a triggering event, or at least a matter in which the court-martial members, as opposed to the military judge, would decide?
Well, because that wasn't the doctor's testimony, Your Honor. The doctor's testimony was that there's always a triggering event, and there wasn't here. Therefore, that...
Where did the doctor say that there was not a triggering event here? Where in his testimony did he say that?
He said that in EM's case, he would be most worried about anniversaries of deaths.
I understood what he talked about in terms of the types of events. Where did he say that this birthday was not a triggering event?
Well, on cross, he says, he's asked, could a birthday be a triggering event? I think at least the government's position is that was sort of hypothetical, almost presented. Could a birthday in persons who have these issues or these mental issues, could it be a triggering event? And he says yes, but on direct, he was...
Well, where did he say that this wasn't a triggering event? I think that was the question.
Well, Your Honor, I don't know that specific line of testimony is I think that the judge's finding of fact is based on the whole discussion about, hey, you know, what occurred in this case.
Well, my understanding of your response to Judge Efron's question was that he did not say that this could have been a triggering event. I mean, I'm just trying to pinpoint what he said specifically.
He said that in this case, he'd be most worried about anniversaries of deaths based on the trauma that EM experienced, Your Honor.
And he did say that birthdays could be triggering events.
Right, but again, I think he was talking about...
But you don't know that. I mean, we're just saying what the record says.
Absolutely. It's an argument, Your Honor. I mean, it's...
Okay.
And just to be clear, triggering events for her to self-mutilate, not triggering events for her to fabricate.
Exactly right. Right, and it wasn't a triggering event for suicide. I mean, the doctor said she was never suicidal. It was simply a triggering event to have the self-mutilation.
To get her mother's attention.
Well, and that brings up another point.
Or was that not clear?
Well, it's certainly that he says they got closer as a result of, when the self-mutilation occurred, it brought the mother and her closer together. But the government doesn't believe that the testimony was sufficiently elicited about this whole theory of attention, either through EM. Part of what the appellant talks about in his brief are these series of facts that simply are not there in the record. He asserts that EM's pressure is building up inside of her between January and September. And that simply is not in the record. In fact, Dr. McMichael's testimony is that EM was doing better than she had ever been in between January, when the last cutting episode occurred, and the events that gave rise to the charged acts in September of 2007. He talks about how he saw her often during that time period, and her test scores, almost the psychological test, have been going up. It's not as if his appellant asserts that this pressure is somehow building up inside of her.
Why isn't that a factual determination for fact finders to make at trial, as opposed to a judge deciding? That is, weighing the time frame in this area, in which some of the incidents occurred as late as 2007, and we have an event that occurred in 2007. Why isn't it for the fact finder to make that decision?
Well, I think the appellant fails to meet the burden of showing the nexus, Your Honor, between these facts that that we believe do not support their argument, but the nexus between this so-called theory. You have to demonstrate that's connection to the charged act. Here, you have this theory that occurs in 2005, a discussion between Dr. McMichael and the victim's mother. Somehow that morphs into 2.5 years later. In September 2007, she creates this whole allegation without, as the military judge stated time and time again, without any direct testimony of her actually trying to kill herself on September 23rd. Those events had no logical link, and certainly, as this court has stated, it's a matter for the jury to determine whether the theory is met. But all the facts in the world, if they don't actually support the theory that you assert them to, and they are talking about events that occurred years before, they simply lack relevance.
Let's take a hypothetical. Let's assume that a person with the same exact psychological history, the same testimony here as the victim in the case, is instead charged with malingering. Specifications that she has cut herself to avoid being deployed with her unit. The person's defense is that she was attacked and didn't self-impose those injuries. Why would the government be precluded, if it would, from bringing in this exact same evidence in the case through the testimony of a psychologist or through cross-examination to establish behavior in conformity?
Well, Your Honor, it would seem to be that on those facts, the link would be direct between the cutting there would equal malingering. I mean, if you were cutting yourself to avoid duty, that by definition almost would be malingering. So it would be direct evidence that went to the offense. Unlike here, where you have this logical leap without the predicate facts that would actually mean the evidence you proffered supports your theory. As the military judge indicated time and time again throughout the trial, if you have a percipient witness testify to this, please call that witness. We'll hear from that witness. But now, that testimony, direct testimony that this was a suicide attempt, would have changed the landscape of this case. But without that, you simply never connected, or the appellant never connected, the facts he wanted to get in with his theory of the case. And as this Court's indicated...
So is it the government's position that the defense was only arguing suicide attempt and that, therefore, nothing else is relevant because no one testified as to a suicide attempt?
No, Your Honor. I think the theory changed a couple different times throughout the trial. At first it was, this was a suicide attempt. This goes to show that she actually did it. Then with Dr. McMichael it became, in order to prove that she did it, I need to connect this whole thing from 2005 and the discussion between Dr. McMichael and the mother, which we don't really know if that was ever conveyed to EM, but then that somehow created this motive fabricated. So the theory sort of changed throughout the trial. But
Does that matter? Was the defense required to have a single theory and prove a single approach throughout a trial, or with respect to raising a reasonable doubt, can it offer multiple theories?
No, absolutely not, Your Honor. The defense can have as many theories as they want, but the crux of the matter is, at each snapshot in time, that the military judge abused his discretion with the proffer that was presented to him. I mean, certainly the defense can come up with as many theories as they want for admissibility of evidence, but we look at each of those theories with the evidence that was before the military judge. The 403 evidence, I'm sorry if the court has no further questions on 401, the government will briefly address 403. The 403 analysis in this case centers on the ability of this evidence to persuade the fact finder to declare guilt or innocence based on issues that simply are not relevant to the charged acts. It's not simply prejudicial evidence, but it's evidence that's unfairly prejudicial based on the way that society looks at mental health evidence. I mean, this is simply evidence that says this girl was crazy. She was crazy when in 2004 or 2003. She's definitely crazy in 2007.
I'm sorry, go
No,
ahead.
sorry. That evidence has a potential to distort the fact finder. And, of course, for that reason, that's why the government believes there was no abuse of discretion.
What about the evidence as source of the injury? Why wasn't it an abuse of discretion to prohibit it on that ground?
I'm sorry, the source of the injury for the...
Right, the self-mutilation.
Well, again, Your Honor, I don't think that evidence was... If there was direct testimony that she self-inflicted the injury, that absolutely would have been relevant. As far as the first theory, that all of this evidence supports that she self-inflicted the injury, we don't think that If you look at what the injuries were in this case, the bruising on the neck and the cut on the inside of the lip, that's not related to the cutting on the arm the majority of which occurred in 2005. And there was just one isolated incident in 2007.
So where in the record do I look, if you know, to find the discussion of the type of injuries they were and how they were different from self-mutilation? I'm not suggesting that there isn't such evidence. I'm just asking you to know where in the Joint Appendix I would find it.
Your Honor, I apologize for not having page numbers. It's the...
Whose testimony?
The NCIS agent. It's one of the two. And it's either an NCIS agent or a CID agent. Your Honor, I apologize for not knowing offhand which institution investigated.
And we talk about self-mutilation, you're talking about cutting, or is there evidence of other types of self-mutilation? Cutting is a distinct issue in certain young people. Is that what we're talking about, or are we talking about some broader context, some broader self-mutilation?
No, the psychiatrist, Your Honor, talked about how it was cutting across the arm, and at one point he believed there was cutting on her thigh.
Did the psychiatrist talk about any other form of self-mutilation other than cutting?
No, he was asked questions about that, and he said that no, he was not aware of anything.
Was there evidence from anyone else of any other sorts of self-mutilation other than the cutting?
No, Your Honor. Briefly turning to the second issue, the government would like to point out, on page 262 of the record of trial, there's additional evidence that actually comes before the fact finder about the medication. The defense counsel asks EM, were you on medication? And she testifies. December 2003, she cites the last time she took medication, and she mentions a couple of periods where her mother provided her Vicodin. That's crucial because what Dr. McMichael's testimony was that she never really became compliant when he prescribed her medication in 2005. So first, the government believes it's not her because the testimony that would not have actually supported appellant. But even going further from that, even if it was her, it would be in no way prejudicial because appellant got the best he could from the medication, which was simply that at one point she was on medication, therefore his belief was reasonable, something he argued to the members in closing. If the evidence he wants to bring in came in, that in fact she was prescribed medication but never became compliant with it, it's factually worse than it is if it was in this case where the members were aware that she was on medication at some point and they were able to argue that appellant's belief was reasonable.
Why wouldn't it be more credible if there was information that at a later point in time she was prescribed medication? I don't recall the accused in his statement saying anything about the details as to the source of the knowledge. So why wouldn't it be for the fact finders to decide whether subsequent information about a prescription enhanced or didn't enhance the credibility of the statements that he made in the incident?
Well, Your Honor, again, if you look at the doctor's testimony, it was she never really became compliant with it.
Yeah, but that would be for the members to decide whether, why wouldn't that be for the members to decide whether he, the defendant, knew that, or whether he, the defendant, would have been aware of the prescription? Those are all inferences from the record. Why aren't those all inferences for the record for the members to decide rather than for the judge to decide?
Well, Your Honor, taking that as a fact, say assuming arguendo that it was for the members to decide, government believes those two facts are crucial for a 403 analysis and, of course, a prejudice analysis. That even if it was for the members to decide, in order to assess prejudice, we look at the effect that evidence would have. And for these reasons, again, that the evidence was not actually favorable to a appellant, it would of course be harmless. And given the non-constitutional error with issue 2, the government needs to prove it or meet its burden to show that it's harmless error. If there are no further questions from this Court, the government would like to simply close by saying that in Schaefer, this Court talks about how the relevance of the evidence must be obvious from the record before this Court will find an abuse of discretion in excluding it. The appellant fails to meet that burden.
Thank you, counsel.
Thank you, Your Honor.
Does the defense have rebuttal?
Yes, Your Honor. Judge Ryan, I think you had 2 questions. I think the first question was what precluded the defense from asking the victim on cross-examination about hospitalization?
No.
Okay.
What precluded them from asking her about wanting to get attention from her mother?
They could have asked that, Your Honor, but without going into the context, without providing the context of that for the members, it would still leave them with this important question of why she would lie. And it's really, we put the cart before the horse if we start asking these initial questions without at least allowing the defense later to provide the context necessary for the members to properly understand the evidence.
My question,
Maybe I got the second.
My question with respect to the hospitalization was what evidence is there that the mother had any intention of hospitalizing her, that she ever knew that there was any such intention at any time?
First, there was no testimony that EM knew about that. But the logical inference is that the members...
What about the second part of the question? What evidence was there that the mother had any intention of hospitalizing her?
The record makes clear...
At that time, or that her behavior had warranted such hospitalization at that time. Wasn't the evidence from the doctor precisely to the contrary? That she had been doing better?
She had been doing better, yes, Your Honor.
So why, if she'd been doing better and had not recently been hospitalized, would she, think that she needed to make something up so that she wouldn't be hospitalized?
Yes, Your Honor. Because of the cyclical nature of this cutting, and because Dr. McMichael testified that EM's mother was always open to her being hospitalized, if the conduct continued, here we have, the defense could have argued before the members, we have this long period of no cutting and she did it again. And because she did it again, she feared hospitalization. The defense
it's not that she did it again, she tried to do it again.
She tried to do it again, yes, Your Honor. And the defense should have been able to present that theory of the case. This is all they had, and there was evidence in the record before the members that she was being untruthful. They should have been able to more fully develop that. And the second issue, I'll just say this. EM testified that she believed that the appellant made these statements about her missing her medication to make her look naturally unstable. This left the members with the impression that he was saying she was basically crazy and needed psychiatric medication. Yet the members were only left with a generic term, that she had been on medication before. They were never given any context. They had no clue that she had ever been on any type of psychiatric medications. In addition, EM said that her last time she was on medication was in 2003. That Dr. McMichael's testimony said that he prescribed her medication in 2005. Had the defense been able to put either Dr. McMichael or probe on cross-examination EM more fully, they would have been able to draw this out and present it to the members. In the end, while these are separate issues, they feed off of each other. Had this excluded evidence been presented to the members, the strength of the defense case would have increased exponentially. No further questions? That concludes my argument.
Thank you, counsel. We thank both counsel for your presentation today. The case is now submitted, and the court will be in recess until 10:15 a.m.
All rise.